Yes, Mr. Bramner.
I'm obliged. Please may I turn to the cross appeal. As we saw before the short adjournment, the Foucaultian judgment prompts questions. It does get people to start to ask, what is its effect? What does this all mean? And we saw a little of that in Mr. Oliver's article. When it comes to the cross appeal, we are interested in ACT and the denial of the FII credit, and only in relation to the denial of the FII credit. FCE does not have a D5 tax claim. In relation to an FII claim, even after Foucaultian, there were still two very significant problems. The first problem was that, unlike in Foucaultian, the UK advanced corporation tax charge was, on the face of it at least, even-handed. There's one single ACT charge. That charge applies both in respect of UK source income or in respect of foreign source income, as the case may be. Secondly, the UK system had an internal logic to it, in that the ACT charge funded the shareholder credit. What one sees as time moves on is that the critical point that's developed in the FII claims, which enables those problems to be overcome, is the point that foreign corporation tax is, in the eyes of EU law, to be equated with ACT. That's what founds the argument that the UK should be giving foreign dividends which have borne foreign corporation tax the same credit for ACT that it gives to domestic dividends, and what provides the answer to what otherwise looks like an insurmountable defence of, well, these companies are in a different position because you're looking at one set of dividends in respect of which no ACT has been paid. And one can see that in action if one runs to the end of the story, if one looks at the Court of Justice's judgment on the first reference. That's in the authorities bundle at tab 17, which should be in volume 3. It's the appeal cases report, which was published very much later in 2012. There was just a very long delay in this being picked up by the appeal cases, but perhaps because by then the judgment on the second reference either had come or was coming. But be that as it may, the judgment starts at page 953 behind tab 17. And I just need to show the court two short passages. They start in the Court of Justice's treatment of question 2, which is at paragraph 75, page 967. That's one passage, and there's another passage which reiterates the same point in relation to foreign income dividends. The court reformulates the question in relation to ACT at paragraph 75, and it's asking essentially whether the UK provisions are precluded when they give credit for residents, but not non-residents. And a key part of the UK's defence is set out at paragraph 85. That's the distinction I was alluding to between dividends on which ACT has been paid and those on which no ACT has been paid. And the court answers that, first of all, at 86. By saying, well, it's still in practice, there's less favourable treatment. And then they deal more directly with the UK's point at 87 to 88. And could I please ask the court to read those two paragraphs? So that's why the UK's answer is a bad answer, and why, in fact, charge, although on the face of it, it looked even-handed, actually it isn't. And that point, so just before I move on from this, that is founded on Metal-Gesellschaft Para 53, which I'll show the court in a moment or two. And that thinking is reiterated in the context of the Court of Justice's treatment of the foreign income dividend issue, which is actually in relation to question 4. That starts at paragraph 140, page 975. Foreign income dividends were the attempted amelioration of the UK system, but there was still a timing disadvantage, and so similar arguments were run out. And all I need is paragraphs 158 and 159. 158 is the UK's argument, and then 159 is the reference back to what the court had previously decided in 87 and 88. So if I could ask your ladyship to read those two paragraphs as well, please. And the significance of Hurst in this context, which the Court of Justice refers back to in its paragraph 88, is that that is the case where the court accepts that ACT is to be regarded in the eyes of EU law as simply a prepayment of corporation tax. And what we'll see is that the Hurst ruling, it puts to one side the other functions that ACT performed. In particular, it put to one side its function of funding the shareholder credit. Even after Hurst, there is still a long way to go. But once one has the judgment in Verkooyen, and once that is coupled with the judgment in Hurst, then at the least an advisor is in a place where there is some material, if one's dealing with an alert and expert and imaginative advisor, that such an advisor can work on and work out that there may be a basis upon which the UK FII system might be capable of being challenged. And that is consistent with what actually happens as a matter of fact. Because as a matter of fact, it is after the judgments have been given, both in Verkooyen and in Hurst, that FII claims start to be made. We know that the first FII claim is Evonik's claim, 12th of July 2002. The unchallenged evidence, which is recorded in the claimant's note on factual matters, paragraph 50, which is page 62 of the supplementary bundle, is that Evonik came to make its claim because it was approached by KPMG. So KPMG came along and told Evonik, we are working on an argument that claimed that UK ACT provisions are contrary to EU law. And so the conclusion that the date of constructive discovery is not before the judgment in Hurst, it fits the facts of when claims were actually being made. Analytically, which is perhaps more important, one needs to look at this actually starting rather earlier in the chronology. I'm working up to a similar point that my friend Mr. Aronson was making yesterday about how ACT actually functioned under the UK system. But if I may, I just want to do this in a slightly more incremental way, because NEC is the culmination of actually a slightly longer process. I'll not take much time with it. But the position in relation to the UK ACT system was that ACT served as a minimum charge at the corporate level to fund the shareholder tax credit. And that's a point that Mr. Gammy noted in paragraph 61 of his report, volume 1 of the unagreed bundle, tab 7. And 61 at page 109, he notes that the payment of ACT and the dividend tax credit formed the core of the UK's imputation system. It's halfway down the page. And he then quotes, that's footnoted at footnote 55, what he quotes from is the command paper all the way back in 1972, which led to the introduction of the ACT system. And that observed that the payment of the ACT and the tax credit, they were the essential link between the company's corporation tax and the shareholder's own tax liability. And that was how the single rate of imputation could be applied, and that was regardless of the effective rate at which the company is liable to tax. And it wasn't just the command paper and Mr. Gammy with all his expertise. Other learned commentators saw ACT, despite its name, in the same way. Indeed, if one looks at what a jointly written article by Freeman and Griffith had to say, they described ACT as being in concept an income tax. And that is in the main supplementary bundle. It's tab 25. The article starts at page 256. I'm very sorry, I've given myself a bad reference. My lady, I'm very sorry. I think I'm looking possibly in the wrong place. Oh, there it is.
Is it Freeman and Griffith?
It is, and Mr. Anson's very helpfully given this to me. I'd given myself the reference in the other bundle, which is no good at all, but it's at the bottom of page 257, I'm happy to say. So I was, in fact, in the right place. I was just looking at the wrong thing. So the sentence I need is, it's under a heading ACT and surplus ACT on page 257. And they explain what surplus ACT is. And they talk about what happens when the company pays cash to its shareholders. To the company, this may look like a company tax, but to the shareholders, all that has happened is that the company has prepaid income tax on their behalf. And then reading on, they say it's working in the same way that deposit interest that banks collect. And then they say it might have been more appropriate to call it advanced income tax. So that's looking at it in very much the same way that Mr. Gammy was looking at it. And then there was a similar observation in the next tab. This was by Mr. Peter Lewis. He was a director of the Company Tax Division at the Inland Revenue. That's at page 259 in this bundle. And within his article, consultative document is one of the documents that leads to the introduction of the FID regime. And he says at page 261 under the heading Roman 3, and perhaps I can make a few points about the background. First, it cannot be said too often that advanced corporation tax is not just corporation tax, pure and simple. It serves a crucial purpose in funding the tax credit attaching to dividends, and he observes that many of the representations and some of the solutions disregard that crucial point. And Freeman and Griffith and Mr. Lewis, they were both writing in 1993. So the UK ACT system, it did have an internal coherence. It's the ACT charge that's funding the shareholder tax credit. And that's in very significant contrast to the Dutch exemption, which had been under consideration in Verkooyen, and which we looked at before the short adjournment. And actually, if anything, as we explain in paragraphs 41 and 42 of FCE's skeleton, if anything, the contrast between the Advocate General's first opinion and second opinion in Verkooyen would have tended to underline that the UK ACT system was coherent and therefore capable of justification. And what provides the building blocks, if I can put it that way, that undermines that line of thinking is the reasoning in Hurst. Hurst, as we saw, was on a very different issue from FII. It was all about the timing of tax paid on UK income. It involved a higher tax charge arising on domestic source profits, and that higher charge arose under the legislation of a single state. It wasn't to do with obligations to remove double taxation. But putting oneself at a time after Verkooyen has been decided, some of the observations that the Court of Justice made, they could, and in the events that happened they did, provide the beginnings of an analysis that would give a basis for bringing an FII claim. What I'll do, if I may, can I fast forward to the judgment in Hurst, and then, having explained that, can I then deal with what one makes of the Advocate General? I appreciate that's not a chronological approach, but I think it will make it easier in the end. So the Hurst report is in the authorities at tab 50, which should be in volume 6. And I'm sure the court recalls the factual context of this. It's all about the complaint of tax being paid too early. And I'll take it short. The court notes, paragraph 6, which is page 2071 of the bundle, that it's important to bear in mind that ACT is not a sum withheld in dividend which is paid in full, but is rather corporation tax borne by the company distributing dividends, paid in advance and set off against the mainstream corporation tax payable in respect of each accounting period. And that's an observation which then becomes critical in the context of the court's treatment of the justification issue. But before the court deals with that, it says a little bit more about the statutory background, and it deals, for example, with set off within accounting periods in paragraph 8, and then there's the possibility of carrying back noted at the end of that paragraph. In paragraph 10, the court's aware that if you don't have mainstream corporation tax in the period in question, then set-off can happen against profits of subsequent accounting periods. And they note that in that case, the advance would have been made for a longer period, even in certain circumstances for an indefinite period. The basic facts are set out in 26 through to 32. I'm not going to take up time with that. the court is dealing with this in the context of its treatment of the first question, which is identified and reformulated at paragraph 35, bottom of 2075. And the point, as the court will recall, is that the resident, the dividend paid to resident parent is capable of having a group income election made, not so for the non-resident parent. And there's a series of justifications that is set out at 45 and following, bottom of 2077. So the UK and others are saying the difference in treatment, which they accept exists, they say it's objectively justified. And a key point there is that there's no comparability, 46. And the UK is saying in 48, if you could have the group income election when there's a non-resident parent, well, there'll be no advanced corporation tax at all in the UK. And then there are further arguments from the Netherlands at 49 and Finland at 50. Those arguments are rejected at 51 and following. And at 52, the court relies on its characterisation of ACT as an advance payment of corporation tax to reject the argument that tax will be avoided in the UK. And it develops what it says at 52, then at 53, noting that the proportion of corporation tax that is not going to be required to be paid, that is in principle paid when the subsidiary's mainstream corporation tax liability falls due. And they say that for the resident subsidiary of the non-resident parent, that's liable to MCT in the same way as a resident subsidiary with a resident parent.
That's all correct, isn't it?
Yes, it is. And then the consequence of that set out in 54, what we're doing is allowing the UK to overseas scenario, if I can call it that, to benefit from the same cash flow advantage as applies in the resident scenario. And then the second aspect of the court's reasoning on this is at paragraphs 55 and 56, which we looked at with learned friend. They say the fact that the non-resident parent isn't going to be subject to ACT, that doesn't justify denying the subsidiary the possibility of exemption under the group income election, because as they explain at 56, the fact the non-resident parent is not liable to ACT, that's attributable to it not being liable to corporation tax in the UK because it's subject to tax in its state of establishment. And it goes on to say, logic therefore requires that a company should not have to make advance payment of a tax to which it will never be liable. And that's why in Hurst, the UK is not able to rely on the overseas parent not being liable for the ACT. And the point they're making is that the overseas parent isn't liable to corporation tax in the UK, but it's liable to the overseas corporation tax. And none of this reasoning is in the context of an issue or addressing directly the question whether the UK is required to give credit for foreign corporation tax. But an advisor now has available to him or her the Foucauldian judgment from which he knows that EU law may have something to say about a member state system for dealing with double taxation relief. And if an advisor takes that observation in for Cohen. So that's the dent, if you like, to the 71 Roman 1 aspect of the consensus. Takes the possibility that comparability may be established, 72.2. Realises that on the face of it there's a problem in relation to comparability because for foreign dividends no ACT is paid, but now thinks, well, hold on a second. ACT is a prepayment of corporation tax, and actually, well, perhaps tax is tax. Perhaps that's what we can take from paragraph 56. Then a very prescient advisor might, at that stage, be able to see that one can argue that foreign corporation tax should be taken into account in working out whether a UK subsidiary and an overseas subsidiary are in a comparable position so far as the ACT charge is concerned. And also that if all that's going on is a prepayment of corporation tax, that it may be possible to attack the link between the payment of ACT and the giving of the shareholder credit.
So, are you saying that none of this? Sorry, that you needed Hertz to make this connection?
I'm saying you need both for Cohen and Hertz.
Yeah.
Yes.
So is the judge wrong?
The judge makes more than he should have done of Cohen in relation to the ACT claim.
I thought you said you conceded it.
In relation to D5, my lord.
Oh, okay. So you're.
I'm differentiating the D5 claim and the FII claim, which is what we did below.
Doesn't seem a very surprising statement that advanced corporation tax is a payment of corporation tax. It's what the statute itself calls it.
My lord, that's right. But
Now, it's true that it also
does other things.
operates to provide the economic justification for the shareholder credit. I mean, further up, but looked at the level of the subsidiary, the one whose profits are being taxed through corporation tax, that's what ACT does. Well, if you make a dividend,
it's a tax on the
you pay a
declaration payment
dividend.
of the dividend, exactly.
You have to also pay some money to the revenue,
Yep.
calculated at X% of the dividend amount, but it is, and you're only going to distribute a dividend if you've made some profits out of which you've got distributable profits. It is a payment of your corporate on account of your corporation tax liability on your profits.
Well, I mean, one needs distributable profits, but one's not necessarily going to have a corporation tax.
Maybe not in the same year, but
Exactly.
in principle, what you're doing is you're paying tax on your profits when you distribute them. That's what you're doing.
That's one of the things that one's doing, Lord, and I don't have any difficulty with that.
But that's all that taxpayer is doing, all that company is doing, because it's not interested in the income tax payable by its shareholders.
Well, that was the burden of showing your lordship what Mr. Gammy had said about the design of the system and what the commentators had said, because
But I understand that from the shareholders' point of view, it operates to fund the credit so they don't have to pay more income tax on their dividends unless they're a higher rate taxpayer. And indeed, if they're an exempt taxpayer, they get it back.
Yes.
I understand all that, but that's from the shareholders' point of view. But are we interested in the shareholders' point of view? Aren't we interested in the subsidiaries' point of view?
Well, Mano, we know now, sitting here in 2025, and I suppose we knew in 2001 with this judgment that that's what we were interested in. What I was showing the court was how this was perceived in the 90s.
Well, I understand that, but my question was, it doesn't seem a very surprising statement that advanced corporation tax is a payment on account of corporation tax, because that's how the statute sets it up.
My lord, it's what section 14 says, and you can see we didn't look at this in the judgment of Mr. Justice Neuberger, but it might the way he actually
It's quoted by the judge, I think.
It is quoted by the judges.
I don't
Some
think
of
to
it
go
is,
to
my lady,
Mr.
yes.
Justice Newberger. I mean, it's there in black and white.
It is in section 14. The only observation I was going to make was that when he gives his judgment, Mr. Justice Newberger records that he thinks it's fantastically unlikely, it's not quite his words, I paraphrase, but very unlikely that the ruling he's just made is going to make any difference to how Hurst is ultimately decided. The point assumes greater significance in the observations of particularly the taxpayers, which we looked at yesterday.
Yes.
I absolutely accept, Lord, it's what section 14 says. I'm not in this court arguing that section 14 doesn't say what it says. What I'm saying is that
it's payable by the company, and the company
Yes.
doesn't pay income tax. The company only pays corporation tax.
Yes.
So it's not surprising that it's corporation tax. And because you take into account against mainstream corporation tax, it's not surprising that it's an advance on your mainstream corporation tax liability.
No, but my lord, there's the point in the judgment is that is the only aspect of the ACT charge that the court is focusing on. The court is not taking into account the other things that the charge is doing. That's the development.
Well, that's because it's looking at it at the level of the company and not at the level of the shareholder, because you've got to have parity.
My
You're
lady,
looking at the same taxpayer.
my lady, I understand that is what the court is doing, but the submission that I'm making is that prior to that, and that's why I showed the court the articles and what Mr. Gammy said, the view was that there was more going on than that.
Well, maybe there was, but I at the moment I'm struggling to understand why Mr. Gammy's view that there was more going on and that it related to individual shareholders has anything to do with it. Because at the end of the day, the question is whether or not somebody at this stage could have tumbled to the fact that the European Court would look at it at corporate level.
Well, my lady, there are 2 points. The first is in relation to comparability. You have, as the UK rightly points out in the passage I showed the court in ECJ1, that on the face of it you don't have a difference in treatment because you're dealing with dividends on the one hand in respect of which ACT has been charged and on the other in respect of which ACT has not been charged, point 1. That's one of the things...
It's a difference in timing only.
Well, my lady, in the context of these claims, we're dealing with surplus ACT, where the tax is never actually set off. And
Right.
Mr. Aronson reminded the court about the ACT Sufferers Club,
Yes,
noted in paragraph 53 of the judgment. This case is factually very different from Hurst. True it is, there are some aspects of the claims that are to do with a timing difference. They're not affected by the limitation point because they actually get a different remedy. The claims that this court is concerned with in relation to ACT are the surplus ACT claims. So it's your ladyship is right that it's a timing point, but as a matter of fact, what we're actually dealing with in this claim at this stage is surplus ACT, which has never been set up. Because the ACT which has been set off has a different remedy, which is the Section 85 Finance Act 2019 remedy, because the Supreme Court in Prudential and then confirmed in Supreme Court 3 overruled Sempra, so there is no restitution claim in respect of time value. And I still bear the scars of trying to persuade the Supreme Court to come to a different view in
But there's a statutory remedy because the Court of Justice said there had to be some effective remedy.
That's right.
Yes.
Yes. So what happened is that in Prudential, it was decided that Sempra should be overruled. There wasn't discussion of what remedy UK law provided because the revenue maintained its concession that Prudential was entitled to restitution. After Prudential decided in 2018, so in 2019, Parliament enacts Section 85 of Finance Act 2019, which gives a statutory remedy to which a different limitation period applies, with which I'm happy to say we're not concerned at this stage. So we're dealing, when it comes to the restitution claims, with the claims for surplus ACT. But there are 2 aspects to this. One is the point of comparability, so no ACT versus ACT charged. And the other is the cohesion point, that the way the system operated, and I absolutely take your ladyship's point, if you just focus in on that one company, you'd say it's happening somewhere else. But in terms of how this was all perceived prior to Hearst, one does have to take seriously what is said by Freeman and Griffith, by Mr. Lewis of the Inland Revenue, that the system was perceived as operating by reference to both taxes, if you like. And in a sense, that's what Mr. Gammy explains about how an imputation system works. The company's tax is imputed to the shareholder. Mr. Gammy, he did deal with this in his oral evidence. It's one line, so it's maybe easiest if I just read what he said. He said that what the Court of Justice had said in Hearst, it facilitated the European Court in separating, if you like, the corporate from the personal tax. And that's in Unagreed Bundle 2, tab 14, page 518. It's internal page 138, lines 4 to 9. So what that reasoning in Hearst does, when you add it to Foucault, is it provides a basis for arguing that there is comparability, as one can see in, I think it was 85 and 86 in CJU1. Sorry, 87 and 88 of CJU1 is where I took the court. And it provides you with a basis for arguing that there is no sufficient link between payment of the UK ACT and the funding of the shareholder credit. That's why this matters. And that's why in my submission, Foucault, while it's essential, it's a necessary step in the development of legal understanding, and you can't get started at all without Foucault. For the ACT claim, Foucault is not enough on its own. That's the submission on the cross view. So Foucault, it's undoubtedly a very important case. It dented important aspects of the consensus, but on its own it wasn't enough. And then I have to deal, well, if I'm right about the judgment, what about the Advocate General? Because the date of the AG isn't good enough to get FCE home. So I was going to go next to what the Advocate General had to say. There's no real evidence on this in terms of perception because this is a new point. So Milano Friend didn't run at trial any argument that the date of the Advocate General's opinion in Hearst was significant. So he didn't explore that with either Professor Barnard or Mr. Gammy. But if we look at what the AG said, within tab 50 in the authorities, what one will see is that his analysis of ACT as a prepayment of corporation tax, it is very much given in the particular factual context of the Hearst case. So his opinion starts at 1998 within tab, no it doesn't, I'm very sorry. It starts at 2043. I'm looking at Foucault again. 2043. I'm very sorry. Advocate General Fennelly. And at paragraph 10, he explains what's going on in terms of the facts. 2047. With the nature of the claim. It's all about a cash flow disadvantage. It's between B and C.
He relies quite heavily in paragraph 6 on the finding of Mr. Justice Neuberger.
Yes, he does. He does, and if one goes back to paragraph 3, it's even more stark, where he says that the National Court has unambiguously found, as a matter of UK law, that advanced corporation tax is corporation tax. So I recognise all of that. Paragraph 11 starts to summarise the UK's submission. They're saying it's important that the ACT was designed to ensure the company making the distribution made a payment to match the tax credit or income tax exemption given to the shareholder. That's then developed in terms of the recording of the UK's submission at paragraphs 18 and 19, bottom of 2051. And 3 lines down, you can see this is being put in terms of the cohesion of the tax system. So the UK is saying this is the purpose of all of this. We want to ensure, just above the letter H, that there's a liability to tax on the paying company. And a similar point is made in 19 in relation to the notion of objectively justified. And it's said to be objectively justified because there's no comparability. Those submissions are rejected, and the reason why is set out in paragraph 22. In the second sentence, the Advocate General says it's clear that advanced corporation tax is nothing other than an advanced payment of mainstream corporation tax. What's important in my submission is that the reasons that he gives for that reflect the point that what that case is about the cash flow disadvantage. Because that's what he refers to in the next sentence, that they're merely going to enjoy the same cash flow advantage as subsidiaries of UK resident companies. And he's saying the case of both types of subsidiary, MCT would in due course arise in the same manner on their respective corporate profits. And as I've said, that's not the position in this case. The point in relation to the payments we're talking about is that the ACT hasn't been set off against the MCT. And I do say that if one is simply reading the opinion of the Advocate General, one will see, yes, he is applying the National Court's conclusion that as a matter of UK law, ACT is corporation tax. But one will also see that his conclusion is very much in the factual context of the claims that were made in Hurst, i.e. cash flow disadvantage. So actually, as a matter of fact in that case, the ACT absolutely was functioning as a prepayment of corporation tax, wasn't dealing with surplus ACT at all. And one will also see that the Advocate General is putting entirely to one side the other functions of ACT. And that last point, that the Court of Justice, go more slowly. Last point, that the Advocate General is saying that in the eyes of EU law, this is how the ACT charge is to be regarded. That would also, in my submission, have to be looked at in the context of the established learning to which I've taken the court about how ACT actually operates. So one would have to bear in mind that someone advising of us on this And if asked the question, well, what about an FII claim? They have for Cohen, which, as I've submitted on its own, isn't enough. You need it, but it's not enough. They're now looking at this opinion, and they know that, as a matter of fact, ACT, it is well recognised as having the function of funding the tax credit. And they're going to know that in a context of a claim like this one, ACT is not, in fact, functioning as a prepayment of corporation tax. And that gives a problem, because true it is, Foucault shows, or at least the outcome of Foucault shows, that maybe a member state may be required to give credit for overseas tax. But on the face of it, the ACT charge is even-handed. Now, if one assumes a creative and prescient advisor, the advisor may say, right, the answer is that ACT is just a prepayment of corporation tax, and tax is tax. But at that point, the problem is the AG's opinion is dealing with the particular facts of the case.
Well, so is the European Court. I mean, what I'm struggling to understand is what the difference is between what the AG is saying and what the European Court eventually accepted.
Well, the difference ultimately really is a pragmatic one, because if one just has the AG's opinion, there is going to be an obvious vulnerability that the response, if one were thinking about should we make a claim, that the response will simply be, well, the AG has actually misunderstood how the ACT charge works. That's not how it operates.
That doesn't stop the claim from being arguable.
Well,
and that's the problem for you, with respect. The claim is arguable as soon as somebody has alighted on the fact that it's capable of being articulated.
Well, my lady, one does have to be careful with that way of putting it, if I may respectfully submit. If one goes back to particularly the preliminaries text, because and that's, we're told, it casts light on what a worthwhile claim is. We're looking at whether there's a sufficient level of confidence to embark on the preliminaries to litigation. And
your submission is that there wouldn't be a sufficient level of confidence based on the AG's opinion, but there would be once you got to a decision of the European Court. Is that really what it boils down to?
That's what it boils down to, my lady.
Right.
And I would add in that context that in relation to the preliminaries, we know, and this is paragraph 190 of Supreme Court 2, that suspicion is not enough. And all I'm saying is that once we have the AG, one is still on the suspicion side of the line. I accept that once you've got the judgment...
So the judge was not entitled to reach the view, as a matter of fact, that a competent legal advisor would have had sufficient confidence to be able to say you can start the preliminaries for a claim.
My lady, and the reason that he wasn't...
He said that at Bacoyan, wasn't
my lady, the judge's finding was that the level of confidence was reached following the Foucault judgment.
Yes.
So I've got to disturb that first,
Yes.
and then if I can disturb,
But you
if
say
I can
that
disturb that, it's between AG
then
and
it's just a
judgment.
question between the AG and between the European Court.
Yes, that's right. And my point essentially is a pragmatic one. I'm not saying, and I can't say, that there is a piece of legal learning in the Haas judgment that one can't tease out one way or another from the AG. The point I'm making is a more pragmatic one, and it's this. If one can't use hindsight, and one has to bear in mind that suspicion is not enough, so you're hypothesising there's advice being given, and all we've got is the AG opinion. The problem one will have, as I've said, is that it appears that the obvious answer is the AG, when he talks about ACT operating as a prepayment of corporation tax, well, either that's specific to the facts of Hearst, or he's just misunderstood how the UK system works, because in fact it does these other things as well. You know the Court of Justice's judgment is coming. pragmatically, one can absolutely see that once the court, as it did in paragraphs 52 to 56, set out the principle that ACT, and this was the court's language, is in no sense a tax on dividends, but rather is an advance payment of corporation tax. Once the court has said that, it's much less likely that the court will later distinguish that ruling. So the level of confidence is going to be higher. One also has to bear in mind that even at this point in time, there is still a very long way to go. Even after House, it's not that House comes out and suddenly the claim becomes an easy one to make. It's not like that at all. There's a lot of work still to be done. What we're looking at is at what point in time does one cross from suspicion, which we're told isn't enough, to a stage where either it's worthwhile claim or level of confidence sufficient to justify preliminaries. And the submission is that in the light of the prior legal understanding as to how ACT works, that level would only have been reached once one had seen that principle recognised by the court, not simply by the Advocate General. Important as his opinion undoubtedly is. I'm sure the court has the point, but the FII claims, they are all about the credit and the ACT. They're not about the mainstream corporation tax. And of course, we know later, and we've touched on this, but only touched on it because it's after the claims are made. The thing in terms of legal principle that actually makes the claims easier to make are then the further developments in Lentz and Manningham. That's what Mr. Gammy pointed to. But of course, that's after Evonik and BAT had issued their claims. But the submission I make, it fits with the facts in terms of what other multinationals would do. And it fits with the development of legal understanding, particularly in the sense that ACT was understood as having a wider variety of functions. And one would need a level of...
A wider variety of functions than what?
Than just being an advance payment of corporation tax.
But you're not saying it wasn't an advance payment?
No, I'm not, Lord. But my point is that that's what both the Advocate General and ultimately the court focus on. They look at that function to the exclusion of the others. That's the point. And I'm sorry if I haven't made that clear. So
I think you have made it clear. I mean, you say that if they'd looked at it as a whole, it might not have reached the same conclusion, at least as far as your client's claim is concerned, and not the deferral of payment way of putting it, which is not your case.
Yes, that's right, my lady. My lady, unless I can assist further, those are my submissions on the cross appeal.
No, thank you very much, Mr.
I'm obliged.
To you.
Can I just recover my... Good afternoon. I wanted to start with, as my learned friend Mr. Aronson started with, the Rudding Committee. As we said before, the Rudding Committee was set up in order to consider questions of harmonisation of tax review. However, I would like to correct, I think it's important to correct a point that my learned friend made about this, which is he said a number of times that there was no there's nothing in the Rudding Committee report about the treaty. Well, that's not correct. There is stuff about the treaty. It is a very long report, as my learned friend said. It's about 400 pages.
Well, if there was relevant information in the Rudding report which specifically mentioned the possibility that there was infringement of these articles of the treaty, I would expect it to have been put before the court before now.
But there is something I want to show you, because I don't want you to be misled into thinking there's nothing in the reading report about the treaty provisions. Can we hand up small? The bulk of the report, most of the report, is not about treaty, of course. It's about harmonisation, and it's very lengthy, and it has a lot of graphs and economic analysis, etc. But there is something about treaty. In fact, the treaty actually is set out in the report as well.
That rather underlines the point you were making.
So can I just show you, this was all before the judge, obviously. So first of all, on what is page 247, we have the contents of the report, and you can see just from that what the various chapters are about. And then we have over the page the list of annexes, which comes after the report. And then we have Annex 10A, which is on harmonisation by Professor Radler. And most of that is about harmonisation and economics, etc. But there is a short paragraph about treaty, which is on page 266. Which is under C, taxation of domestic dividend income. Now, it's not about the UK system. It's not aimed at any particular system. It's just a sort of general statement.
266.
266. In the middle of the page, C, taxation of domestic dividend income and of dividend income from other member states. And it only goes to say it might be a breach of the treaty. Now, the reason why taking claims to the European Court under the Treaty of Rome was not regarded as being an answer to harmonisation is twofold. One, as you can see at this time, it was uncertain what would happen if claims were brought. But secondly, it wouldn't solve the problem, because it would only produce a piecemeal solution, or piecemeal, sorry, it would provide piecemeal, and there might not be a solution. You might end up with a response to cases, which is not what you wanted to happen. So for instance, one solution to problems about cross-border dividends is to go back to a classical system, just such as the Dutch have, because in that system you're not giving any credit to domestic dividends, you're taxing them fully. So you can do what you like with foreign dividends. You can tax them, you can give them a credit, you can do whatever you like, because you're not going to treat them less favourably than domestic dividends. That's the point. So the treaty challenges are all about the difference between domestic dividends and foreign dividends, and they're not going to create a whole system for the whole community, which is what this was all about. This was all about how we're going to create the best system in economic terms, etc., for the whole community, so that everybody uses the same system, it's a common system. All these problems about disparities between the different systems don't arise. So that's what the Reading Committee report was about. But I didn't want you to get the impression that those who were doing it were unaware of the fact that challenges could be brought, obviously, the Treaty of Rome. So that's the Reading Committee. I don't think there's anything that helps you really in having the Reading Committee. And we say it's irrelevant to the legal question that you have to answer. Although, one comment I would make about that is that the judge assumes in paragraph 62 of his judgment that the appropriate advisor would be aware of the Reading Committee report. Now, he doesn't say that he would have read it. I'm not quite sure what he means by being aware of it. But anyway, this is one of the problems with this approach to it. what work do you expect the appropriate advisor to do? What level of work? It seems like not very much, according to the judge. He's sort of got a general understanding and a general background, and that's about it. Which I think, as I said earlier, was not a realistic approach that any advisor would take. Then we have the bit from the Farmer and Lyle's book, which my learned friend referred you to. That is in the joint supplementary bundle, page 270. This is the passage that continues after the passage the judge cited. Now, of course, the reason I was dealing with the passage on page 269 is that's the passage the judge cited in his judgment as, he said, supporting the consensus. And I've made my submissions as to why he doesn't have anything to say about this particular, the outward investment situation, FIR. But then if you go over to 270, it's talking about the Parent Subsidiary Directive, which, as you have seen, requires member states to relieve double taxation in relation to foreign dividends by either one method of the exemption method or the imputation method. And what he goes on to say is, relief granted, the tax relief granted by the directive to parent companies in respect of distributions of profit received from their subsidiaries goes further than Article 52 by requiring the member state to take account of tax paid on the member state. And the point they're making here is simply Article 52 in itself doesn't require, necessarily, doesn't require that the member state of the parent company should take account of the tax paid in another member state. For instance, if that member state has a classical system like the Dutch had at the time, and I think other member states had, it wouldn't. Article 52 would say nothing about it. It wouldn't be required by Article 52 to give any relief at all. And the point they're making is the directive goes further, and no matter what your domestic system is, it requires you to provide relief for foreign dividends. So there's no, it's not the same as Article 52, which is really looking at disparity of treatment between domestic dividends and foreign dividends. So that's, in my submission, simply the point that they're making, this paragraph. And then just briefly, there's a point that keeps being made about how important this case is, how novel it is, because it's taking account of foreign tax and giving a credit in the UK, for instance. But double taxation treaties already do this. I mean, you know, that's the way they work. They give a credit. You as a state of residence of the shareholder have to give credit for the tax that's paid in another state against your tax charge. So you're giving up the right to tax.
The point is that that's done voluntarily by states
Oh,
as a
yes.
result of international treaty,
Exactly.
rather than it being imposed on them by the CJEU.
Well, only imposed on them if they are discriminating in relation to the domestic situation, of course. But yes, you're right, there is that difference. But it's not that giving credit for foreign tax and giving up the right to tax is a novel idea.
I don't think anybody's suggesting it's a novel idea. The suggestion is that it cuts across the idea of member state autonomy in terms of how they tax profits that are realised in their jurisdictions. And unless they voluntarily decide to give up the right to tax, then it's just to be assumed that, or it was assumed until these cases, that they hadn't.
Well, that's the argument that's being
Yeah.
raised. Yeah. Yes. All I'm saying is it's not an unusual idea, and all that ended up happening in this case was that the credit that was given was higher, not in relation to foreign tax at all, but in relation to the foreign tax rate in the end. So then we have the significance of the case law, and my learned friend has taken you to the various cases. it's not what we say that any of these cases directly impinge on cross-border dividends. Of course, everyone accepts that that's not the case. What we say the significance of these cases is the principles that they set down, which are applicable and are part of the, using Mr. Ramgami's idea, the building blocks in which you would be able to come to the conclusion, if you were thinking about it, that there could be a claim in relation to FII and D5 tax and the ACT.
Well, you would at the time have come to that conclusion.
I'm sorry?
You would at the time have come to that conclusion.
You would at the time, yes, because these are all cases that have been decided.
Even though nobody did.
Well, nobody in the UK, I think, it's fair to say. When you say nobody did, nobody came to the conclusion that the UK system was. I think that's correct. But we say that's not surprising, and there was an example of exactly the same thing in relation to Hirsch. Remember, I asked Mr. Gammy about this because there was nothing before Hirsch brought their claims in 1995 suggesting that they would be able to bring claims, and nobody brought claims. But Mr. Gammy accepted that you could have brought claims going back. I think we went back to 1990, but certainly probably
91, I think he said.
Yeah. So there's no reason why you couldn't have brought the claims. The time that the claims were brought in our submission is very often a matter of happenstance. Just depends on circumstances coming together. You can't draw any conclusions from the fact that claims weren't brought at a particular time and suggest that it couldn't have been discovered at that time. That wouldn't be, obviously that can't be right, because otherwise you would not have the idea of discoverability. The whole idea of discoverability is it's a time when nobody did actually obviously discover. So the concept itself assumes that there are situations in which people can have to be in a position where they ought to have discovered using reasonable diligence something that nobody actually did discover at one time. So we would say the fact
I'm not sure that's right. If you're trying to impose a limitation on period on somebody, I mean, paradigm case is where everybody else is bringing a claim, and somebody just sits around on their hands and doesn't, and then you just say when they somewhat belatedly do, oh, too late, everybody else was.
Yeah, but they would have actually discovered it then.
Not necessarily. They
Not necessarily, they might be ignorant of it.
Correct.
Well, they
Or
might
they
get bad advice.
Yeah, they might just be bone idle.
Well, being bored idle doesn't stop the limitation period. I mean,
Right.
No, that's
you would
exactly
have
my
discovered,
point.
you could have discovered it, but decided not
That's
to.
exactly my point.
Yeah.
I mean,
You could have actually discovered it. Now, it could be that you just didn't know, and people were bringing claims that you didn't know about. Is that? I think that's what you're suggesting.
Well, that's the paradigm
that's what
case. This is
about.
the problem. As the Supreme Court said, there are cases in which you make a mistake of law, but your date of deemed knowledge is the date of the payment, because you could, with reasonable diligence, have found out if you bothered to
Yes,
ask.
That's a case of ignorance.
That's one situation. Here we're dealing with something slightly more nebulous, which is what you could have discovered if you'd taken appropriate advice at the relevant time.
Yes.
sorry, the reason I got into this, maybe I just misheard you, but I thought you were saying the fact that nobody was bringing claims is of no evidential significance.
I'm saying that, no, I wasn't necessarily saying that. I was saying the fact that nobody was bringing a claims doesn't mean that it's not discoverable.
But it doesn't prove it's not discoverable,
doesn't.
although
It's
it
all
is
from that.
it is
It's a
a factor.
Yes. I mean, the question is, why were nobody bringing claims? Maybe.
And Mr. Gammy's answer to that is because there was a consensus there were no claims to be brought, and you say, well, you can't necessarily agree with that. But
Yes. Well, I don't agree with that. And what we say is that wasn't what Mr. Gammy said. What Mr. Gammy was saying was,
well, we've been over that.
yeah, it's all about a misclearing, and you can see that from, the fact that people did
We'll have to
recognise
make
it.
our own mind up as to what Mr. Gammy said and whether or not the judge rightly characterised it.
Yeah. Yes, exactly. So can I then deal with Verkuyen? Because what we say Verkuyen is, and the judge's decision on Verkuyen is all part of the error that he made in assessing the factual situation at the time. Can I just make it clear? What we say is the judge ought to have considered together questions of was there a consensus and how did it operate in the light of the fact that claims were brought in 2002, 2003. It seems that it was discovered at least then. You have to then consider the question, well, how did that come about if there really was a consensus in the past? And when did the consensus end? And that's all part of the factual decision making. Because inevitably, you've got to make sense of the whole thing as a factual matter. Now, the problem is that the judge appears in his judgment to have decided the Verkuyen date on the basis of a concession that was made by the test claimants. I mean, if we look at what the judge said about that. He said, if you turn page 208, paragraph 113, he begins at 111 and sets out Verkuyen. And then he says, at paragraph 114, the CJA's reasoning struck right at the heart of the professional consensus as described in paragraph 71 above. Now, he doesn't explain why that was, and we would agree with Mr. Bremner that that's not correct. It can't have struck at the heart of various elements of the professional consensus that he set out in paragraph 71, because it simply doesn't deal with any of these. I mean,
well, I thought your case was that
this was a very
professional
firm consensus that lasted for decades, which is what the judge seems to suggest, an absolute consensus, a strong consensus. Then what was decided in Verkuyen couldn't possibly, for the reasons that both Mr. Bremner and Mr. Gammy set out in his report, couldn't possibly have dismantled that entire consensus.
Well, not even.
As they point out, Verkuyen is not.
Even Mr. Bremner says it was dented.
Well, he says it's I don't know what that means, but it would have to be dismantled. That's what the judge says. For it to be.
Well, he says it's dented because he's got a cross appeal.
Yes, but I'm dealing with our appeal at the moment. I'm dealing with our appeal, and I'm saying the judge had to look at this together. He couldn't decide when there was a consensus and then decide it had been dismantled by Verkuyen without explaining why it was dismantled by Verkuyen.
Which bit of the consensus he describes in paragraph 71 did you understand him to say in paragraph 114, 114 or 116.
Yes. He just says the same thing.
Well, yeah. Either striking right at the heart of, or dismantling, whichever thing you choose. Which bit of 71?
Well, it would have to be all of it in my submission, because each element of it on its own would be sufficient to keep the consensus going, but you can bring these claims. If you look at 1, 2, and 3, they're each sufficient in themselves.
Well,
because if
I thought when we looked at it earlier that you could certainly see that 71 subparagraph 3 was affected by Verkuyen.
Well, in my submission, no, because Verkuyen didn't go any further than the cases that were already decided before 1996 on Bachmann. So it didn't make any difference to the position. But anyway, even if it did affect the Bachmann part, it didn't affect the other two parts, and they're enough. Because if there's no comparability, then there's no claim. And one seems to be basically saying this is off limits.
So you're both saying that the judge is wrong.
Exactly.
For different reasons, because you want to move the timeline in different directions.
Well, I suppose that's one way of putting it, but we say he's wrong because we say he's wrong, and the consequence of that is he hasn't grappled with this properly at all, because he can't decide one thing in relation factual question and then not decide the other thing as a matter of fact. I mean, the other problem with his decision is it's contrary to the evidence that was given by Mr. Gammy, which was not, well, it's contrary to Mr. Gammy's evidence, which was this was not dismantling the consensus. What for Mr. Gammy dismantled the consensus was Lenz, Mannon and Marks and Spencer's. But secondly, it's also not in accordance with the other evidence. Because if there really
You're now
was...
criticising the judge for not accepting that evidence on Mr. Gammy. No, you're not.
I'm saying that he cannot decide there's a consensus solely on Mr. Gammy's word, but then not follow it through as to what Mr. Gammy said about when the consensus came to an end. It doesn't make sense to pick and choose.
Okay.
To start by making it...
I thought the whole purpose of having an expert opinion is that you're guided by it and it's not a tramline.
Well,
so that you can accept an expert so far, but then if the judge is doing the exercise that you've been urging us all along we should have done, which is look at the case for himself,
yes,
he can decide what the answer is to the question that's been posed.
Well,
so why can't he say,
well, he should have done that.
I think Mr. Gammy was too late in terms of what he says.
He doesn't even say that. He doesn't grapple with the fact that Mr. Gammy's... He seems to... I mean... The only justification given for this is paragraph 116. The claimants were right to accept there must be a constructive discovery relevant to the D5 challenge.
But he's not basing it on a concession.
Well,
He's saying the concession was rightly made because he agrees with it. In other words, he has formed the view for himself that was appropriate.
But he says so, but he doesn't explain why it struck right at the heart of the professional consensus. And in my submission, it's not rationally supportable that it did. Because the decision itself is about, as has been pointed out, about individuals. It's about a classical system of taxation. It has nothing to say at all about an imputation system. And it's nothing to say about the long-standing accepted understanding that distortions created by cross-border dividend taxation systems will only be addressed by legislative action. It doesn't set that. It doesn't dismantle that. Nor is it anything to say about comparability in the context that we're looking at, which is parent subsidiaries paying dividends and then ACT being paid, etc.
Well, it does say something about back and coherence.
It does say something about Bachman, although, as I say, it doesn't take Bachman any further forward than you would get from reading Wheelock's and Bachman itself. Cases, it doesn't apply.
Bachman and Wheelock's suggest that they're outliers on factual cases, and the majority of cases it won't be affected because there is going to be comparability. You then get this case which suggests that that's not so. I think actually if one traces it through, you're wrong about that, with respect. You see all the caveats in Wheelock's and Bachman.
Well, there are no cases that say that comparability applies at the level of the subsidiary. The only cases about comparability are about the resident and non-resident taxpayers. That's Schumacher and I think Wheelock's. No case has addressed, even remotely, the question of what's the position with parents who are receiving dividends from non-resident companies. That's just a completely different issue.
That
So
rather
with great
sort of
respect,
cuts against your case, Mr. Hewitt.
Sorry?
That rather cuts against your case. If nobody was thinking about it, nobody addressed it, then you're left with the consensus not being dismantled even then.
Well, the conclusion would have to be either there was no consensus, or there was a consensus among some advisors, but not others, the others being the ones who obviously brought the claims. And that seems to be the only rational conclusions that you can come to on the basis of the evidence that we have. It's not, you can't say on the basis of the evidence that Verkuyen dismantled the consensus. And if you were going to say the judge is entitled at this stage to decide for himself what happened to the consensus, then that, I would submit, is inconsistent.
Where do we
with
find
him-
this rationality challenge in your grounds of appeal?
It's in ground.
Where is it said it was
says in-
irrational for the judge to reach the conclusion that he did?
It's in ground 3. Oh, yeah. It's page 17, paragraph 4, ground 3. The judge is finding there's a professional consensus that the E5 challenge would not be worthwhile on no rational basis. Similarly, is finding that such a professional consensus was dismantled by the judgment in Kuyen had no rational basis.
Right, thank you.
And we do deal with it in our skeleton.
Yeah. I just needed the cross-reference.
Yes,
Thank
yeah.
you. Yes.
Yeah, so we say that's not a rational way to, a proper and rational way to deal with findings of fact, if that's what is the appropriate thing for the judge to do. You already have a primary case, which is that's not the correct approach. Our alternative submission, which I think my friend was dealing with, was, well, if Verkuyen did all of this and was so important, then what was decided, what happened in Verkuyen could have been discovered years earlier, since it was discovered by Mr. Verkuyen and by the Dutch court. That's our submission, alternative submission there. So we say you can't have it one way or another. Either it was discovered much earlier, or it didn't rationally affect. It couldn't be said rationally that it affected or dismantled the consensus. Which means, I mean, what the judge seems to be saying is, for decades there was this consensus of view that you couldn't possibly bring these claims. And then overnight, there's a decision of the European Court, and that entirely vanished. Now, that, as I said, that's also contrary to the other evidence. The judge himself cites an article, Mr. Oliver, which he describes as muted. Now, if really you had dismantled this concession, it lasted for decades, the response would not be muted by any means. The response would be, goodness gracious, look what's happened. We've all been thinking there's no claims, but now, suddenly, we can see that we can bring these claims, or types of claims, or we can challenge this.
Well, that's more or less what he says. He says you can bring certain types of claims, but it's questionable whether you can bring others.
He says that it affects, it's about individuals, but the position as regarding companies is not at all clear. It does not.
Exactly. So he's actually alive to the fact that it may go beyond individuals, but the position isn't yet clear.
Yeah.
Well, fine, but he's alert to the point. He's alert to the arguability at that stage.
Well, it doesn't read as though he's suddenly. I mean, I suppose it may depend upon what the ladyship thinks is the standard that we have to reach to dismantle a consensus like this, whatever that means. And one of the problems, I think, is. But dismantling the consensus rather sounds as though suddenly everybody has realised that consensus doesn't apply.
That just means
Well,
that
it's
not
incorrect.
everybody is agreed anymore. That's what it means. A consensus is an agreement, and there are people who no longer hold that view.
Right, well, there's no evidence
Including Mr.
that was the
Oliver.
case. There was no evidence, in fact, that people held any view beforehand. That's the problem. It wasn't a consensus in that sense.
Well, we're going back over old ground, Mr.
Yes,
Hewitt.
but that's the trouble with
I
using the term
think
consensus.
we need to move on.
Yeah. So then can I just deal with the cross appeal briefly? And we've dealt with this obviously in a skeleton in some detail. What is being said is that Hurst made an enormous difference. The judgment in Hurst meant suddenly you could see things that you couldn't see before. You've had my submissions already about the fact that this was a matter of decision by the domestic court. It was all in the observations. One could draw the inference that despite what Mr. Justice Neuberger said, that maybe the claimants or the plaintiffs in those days actually did appreciate the importance, or the potential importance anyway, of that point, because they exploited it in their written observations quite soon after. So I'd be surprised if they weren't alive to why they were arguing the point before Mr. Justice Neuberger. But the point is, it's perfectly obvious from the legislation. It's a point that anyone could discover at any time. And in Hurst, there is no, there's nothing in Hurst which says that foreign corporation tax is the same as UK corporation tax. It doesn't say that at all. It simply makes a point that a foreign parent isn't liable to corporation tax in the UK, brackets, it's liable to corporation tax where it's resident, and therefore it can't be liable to advanced corporation tax. And so the Revenue's argument that this will this somehow breaches, I don't know, the cohesion of the tax system or something like that, by not having ACT paid at the parent level is just beside the point. ACT is paid, it's a prepayment of corporation tax at the subsidiary level, and that's that. Both subsidiaries of foreign parents and subsidiaries of UK parents pay corporation tax. That's the point they made, which is obviously right. There's no difference. The only difference was that the subsidiaries of foreign parents had to pay it in advance because they couldn't make a group income election. That's the timing difference. But it also seemed as though my learned friend's argument, when he came to talk about the, I think at this point the court made the Advocate General's opinion equally applied to the court's opinion. They're both of a piece, and they both follow the order for reference as regards the critical point, which is that ACT is an advance payment of corporation tax. So either, if there was something great in Hurst, it could have been discerned from the Advocate General opinion, but more likely there wasn't anything. And we also have the evidence of Mr. Gammy, who didn't regard Hurst as being even a stepping stone in this whole thing, if you remember. And his view was that Hurst was a perfectly predictable decision, and he predicted it in 1995, if you remember his article, that they would succeed. So he didn't regard that as a surprising decision or anything groundbreaking that moved everything on further. That was his evidence in cross-examination. But he also, in his report, he doesn't include it as one of the stepping stones in the way to FII. So, both as a matter of analysis of the decision and as a matter of evidence, we would say Hurst is not the critical case. That leaves you, of course, with having to say, well, either Vacuum is a critical case, or again, going back to my point, that nothing occurred before the cases were brought, which produces a rather difficult situation in the light of the findings of fact about the consensus. But I'm not going to go over that. It's the same point, really. Except it's stronger because I think both sides agree that Vacuum really had nothing to say about ACT in particular. Can I just one small and probably irrelevant point, but about third country claims. I think my learned friend mentioned those. He's right that there are some third country claims, but in this GLO, for various technical reasons, which I perhaps won't bore you with, they only go back to 2000. The reason being that there is a standstill provision in relation to third country claims, and the court has held, the Supreme Court held in the third Supreme Court decision, that the that it ended, the protection of that ended in 2000 when there was a change to the legislation. And so it's only from 2000 forward that these third-party claims are can be made in this GLO.
As it turned out, yes.
As it turns out, yeah.
Yeah.
So we don't have, in short, there aren't any limitation issues, as it turns out, in relation to third-party claims. So unless there's anything further.
Thank you, Mr. Ewart. Mr. Anderson, Mr. Bremner, any point on the cross appeal?
Just three short points, my lady, and may I just make, before I do those, just one very obvious point on the Ruding document, which was handed up for the first time. One line out of over 400 pages. No commentary on a system like the UK D5 system complying with parent subsidiary directive. No commentary on a system like the UK ACT system, which appears to be even-handed. No assistance at all in the context of this debate. The 3 points on the cross appeal are these. First of all, in terms of where one starts. One starts after Foucault, and Mr. Gammy was very clear that Foucault was a significant case. That was paragraph 53 of his report, which I took the court to. My friend said, well, Mr. Gammy says Foucault has nothing to do with it. Not so. He was absolutely clear that Foucault was one of the key developments. It's one of two key elements, was the phrase that he used. We also, in relation to Foucault, we had the evidence of Mr. Kong, one of the tax managers, I think, at BAT, which is set out in Supreme Court 2, paragraph 33. And Mr. Kong's evidence was that it was after the Foucault judgment that BAT started to look at the question. And after the Foucault judgment, one has Mr. Oliver's article. Oh, I'm so sorry. If Your Lordship would like to see paragraph 33 of what the Supreme Court had to say, it's in the authorities, and it's going to be in volume 2. Having failed to give myself a bookmark, 33 is on page 744. So what actually happened round about C and D on 744, the first time we considered the denial of FIR treatment might be breach of EU law was when we discussed internally for Colin. Following this, we spent a considerable amount of time considering our options, waiting to see how EC law would develop, etc. And then the claim issued in 2003. And then the other thing that comes after Foucault and that is of significance is Mr. Oliver's article, 2000 British Tax Review, and that is somebody starting at least to ask questions. And my friend can make all the linguistic points he wants about dismantling and the like, but the reality is once somebody starts asking questions, it's much harder to say there is a consensus because people are questioning the position. That's what Mr. Oliver is doing. His article is dealing with D5, not with ACT, but that's why the point was put to the judge in the way that it was, in the light of the evidence in relation to what happened after Foucault, and one can see that in relation to D5 there are questions being asked. ACT, for the reasons I've gone through, different story.
What does Mr. Cohn mean in his witness statement when he refers to the denial of FII treatment of foreign dividends might be a breach of EC law? That's not the D5 question.
That's not a D5 question. No, that's looking at that is looking at ACT. Mr. Hardman, Mr. Khan's boss, he does talk about D5.
But does not Mr. Cohen then give evidence that he thought, or whoever we is, his team, thought after Vercoyen, shortly after it was published, that it might have implications for FII, ACT?
That's his evidence.
Yes.
Yes. And that might go towards a point on actual discovery in relation to BAT.
Well, if someone has actually discovered it, then it clearly could be discovered.
Well, my lord, not necessarily. Not
You can't
necessarily.
discover something if it's not discoverable. If you discover something, it must be discoverable.
My lord, but just pausing there just for a moment, if I may. It's discoverable with the exercise of reasonable diligence. It's not a purely conceptual question of is it discoverable.
Yes, but you're assumed to want to ask, and we actually know, I mean, it's all over the papers, that the people who suffered from surplus ATT were constantly asking if there was anything
They
they
were
could
really
do
cross
about
about
it.
it.
Well,
And
my lord,
BAT was at the forefront of that.
and one.
So I understand that in principle somebody might stumble across something that most people wouldn't uncover with reasonable diligence. But when you have somebody who's the head of tax who is looking for a solution to a long-standing problem, and he says in evidence, shortly after the coin comes out, then we start thinking whether we have got an answer. And he doesn't say we came to a conclusion we had an answer, but he does start saying we questioned it. And that at least looks as if it's some support for the judge's view that it's the coin that is significant, not just for D5 but also for ACT.
And I can see it in the context of BAT, a particularly alert and engaged taxpayer.
Yes.
The note which was prepared during the trial, which is in the supplementary bundle, tab 8, it sets out in tedious detail all the steps that BAT took. Tax planning, tax litigation, group reorganisations, all aimed at dealing with the problem, all with the benefit, one can tell, of very expert advice, leading law firms, leading accountants, no doubt extremely expensive. At no point in all of those steps, plainly, was the question of a treaty challenge ever raised. But what you do have is BAT, who one might say are at the vanguard of all of this. Yes, they do have someone who, for them, that was the start. It is also just worth looking at what Mr. Hardman, who was also at BAT, had to say. It's actually most conveniently located, my lord. It's in 51 of the FCE skeleton, which is page 98 of the core bundle. Mr. Hardman was the head of tax, certainly at one time, at BAT. Mr. Khan, I think, reported to him. And it's slightly more nuanced, and Mr. Hardman's focusing on D5. I don't need it in the original, but it's page 8 of the supplementary bundle is where that extract from Mr. Hardman's witness statement is. It acknowledges a possible read across from Vercoyen to the UK system. They didn't think about whether this meant we should change our way of doing tax returns. They thought they still had to lodge their returns in accordance with the law, but he did ask team members to keep their ears open and report any further developments. So I do say one can't lose sight of the fact that this is discoverability with the exercise of reasonable diligence.
What does the second half of 104, as reported, mean there? I mean, discovering it definitely meant that the UK dividend taxation was unlawful is not the test.
No.
Correct?
What it shows...
So he says, although it was acknowledged that there was a possible read across between provisions which tax dividend receipts differently in the UK system, where there was an exemption system for the taxation of UK dividends locally, but a credit system to tax dividends from non-residents. In light of Vercoyen, isn't that consistent? with
consistent with what, Lord? I'm so sorry.
with discoverability.
Well, it depends what one does with the threshold, because we know that suspicion isn't enough. I mean, this is evidence Mr. Hardman gave back in 2008. He gave evidence at that time. I can't remember now whether he gave oral evidence as well. One just has to read what he had to say. All I'm saying is that after Foucault, people are starting to ask questions.
Yeah.
And it's a much clearer case in relation to the D5, where there aren't the additional complications of one, an even-handed charge, and two, the point on cohesion in relation to the funding of the credit. But just to complete the point I was starting to make in answer to my Lord Justice Nugee, I do say that constructive discovery doesn't necessarily precede actual discovery. You can have claimants who are particularly either well-informed or particularly ambitious, who might be in the vanguard. And then the third and last point was just in relation to FCE, two very small matters. One was that I hadn't quite summarised correctly what Mr. Justice Neuberger had said when he actually made his decision about the nature of ACT. So please may I just put that right. It's main supplementary bundle, tab 11, starting at page 76. I think I'd used words like vanishingly unlikely or something of that nature, which possibly went a tiny bit further than I should have done. It's page 80. The sentiment's the same, but the language wasn't quite the same. Page 80, this is the transcript of his judgment where he decides that the point about ACT as a prepayment is going in the order for reference. And it's line 6, starting the third point. Raises a point of some interest, although I suspect he made really of academic interest. He identifies what the point of principle is advanced corporation tax, or is it a separate tax, although I have considerable doubt as to whether this in fact will make the slightest difference to the way in which the arguments will be presented to the European Court, and would be very surprised if it made a difference to the decision of the European Court. He'd been persuaded it may make a difference to the way the arguments are presented. So that's why Mr. Justice Neuberger said really didn't regard this as a point. He thought it was determined by what Section 14 said. The Court has my submission that, yes, absolutely, ACT is corporation tax, the section tells us that. Yes, absolutely, one of the things it does is function as a prepayment. That's not all that it does. And last point, one also can't lose sight of the impact that Hearst has been viewed as having. It is a thunderbolt from Luxembourg. That's not just me saying that, that was Lord Walker in Pirelli, paragraph 104. It's a case of real significance, particularly after the judgment has come. And so just where we get to in terms of the cross appeal, Foucault is the point where for the first time there's suspicion. And the question is, at what point does one cross from that into worthwhile claim and confidence to embark on preliminaries? The Court has my suspicion as to why that's later than Foucault, and as a contest between the Advocate General in Hearst and the judgment, why it's the judgment that one should be looking towards. Unless I can assist further, that is my reply.
Thank you very much, Mr. Bremner. Well, thank you to all counsel, and thank you to all those sitting behind them, other counsel, and also the legal teams. We know an awful lot of hard work goes on behind the scenes to prepare a case like this. You've all given us a great deal of food for thought. We will reserve our judgments. They'll be handed down in the normal way, and of course there will be no need for attendance when they are. We will circulate drafts of our judgments. I hope that by now all of the information has been sent to my clerk so that we know who the people to whom the copies will be distributed. I anticipate that there will be people within the departments of your clients who will want to see it, but the usual restrictions will still apply, and therefore the judgment is only to be distributed to those people whose names are on the list, and of course it must be maintained as confidential until such time as the judgments are formally handed down. We will give you obviously a reasonable time to come back with corrections. Corrections, of course, will be typing or obvious factual errors only. It's not an opportunity to re-argue the case, and I can't give you promises as to how soon that will be done, but hopefully it won't be too long. Thank you all very much.
Thank you.